Okay, good evening, guys. Let's start. Our agenda now is to solve RTP and past exam questions of almost close to last 4 to 5 attempts. At this point, we have finished the concept revision. We have done questions of regular chapters also. Let's straight away focus on revision. Okay. We will also focus on presentation during the class. Maybe one question of your choice I will dictate in the class towards the end of the class. How do you present? We know we have to present using facts, provision, analysis, conclusion. I will again dictate one of these 60 questions. We have totally 60 questions. The idea is to solve all these questions quickly in the class. Okay. How we are going to do it is, since this is stream live recording and even we have students here, the whole point is, in exam, I want you to be independent. You are watching this after a good revision of law, correct? No, sir, I am studying law after 1 month. Don't see this video. Don't do the questions. I have revised law. I just need a quick 1 hour confidence or 2 hours confidence boost of going through questions. So this is going to be like, for every question, some questions I will read, some you will read, but you will think of the answer in your head. And we will discuss the answer in the class. Whichever you feel is complicated, I will discuss in detail and keep moving on to the next question. Are you all able to follow, guys? That's what we are going to do now. Once you do this, am I considering all the past exam and RTP questions of last 5 attempts? No. Whichever I feel is complex, difficult, material, those kind of things only I have taken here. Okay. Now, first 1-2 questions maybe I will read, then you will read. So let's start, guys. Question number 1 from RTP May 21. I won't read in every question. You can see that. Okay. S, aged 58 years, was employed in government department. He was going to retire after 2 years. D made a proposal to S to apply for voluntary retirement from his post so that D can be appointed in his place. D offered a sum of 10 lakhs as consideration in order to induce him to retire. S refused as the first instance, as the amount offered as consideration is just double of his cumulative remuneration during the next 2 years of employment. He agreed to receive the consideration and accepted the above agreement to retire from office. What is the validity of the agreement? It is what? Valid or void? Void. We know agreement should be agreement plus essential element makes it valid contract. One of the essential elements is lawful object and lawful consideration. This is agreement opposed to public policies, traffic relating to public offices. Therefore, this becomes a void agreement. Are you able to follow? Not enforceable. Are you understanding? That's it. Hardly 1 minute per question. Quick revision. Next, question number 2. In the provisions of Indian Contract Act, answer the following. As we keep going, I will leave the question reading also to you. Okay. S and R made a contract where S agreed to deliver paper cup manufacture machine to R and to receive payment on delivery. On fulfillment date, R did not pay the agreed price. Decide if S is bound to fulfill the promise. Should he fulfill it, guys? Hello? No, not bound to fulfill the promise. Why? Reciprocal promise says, I will perform my obligation only if you perform the obligation. Unit 4 of Indian Contract Act. Are you able to follow, guys? Next. Y has given a loan to G of 30 lakhs. G defaulted the loan on due date and debt became time barred. After the time barred debt, G guaranteed to settle the full amount to Y. Whether acceptance of time barred debt is enforceable in law? It should know unless it is in written. It should be written by the party. Then only it becomes a valid contract. Here he is saying he agreed to settle. Nowhere we are talking about in writing. So you will say it's not valid because we are presuming this is what? Oral. Able to follow, guys? Speed all right? Hello? Wherever you feel, sir, I have a doubt, just put your hand up or put your doubt in the chat, those who are watching YouTube or Google, and then I'll take up your questions then and there. Next, A and B entered into a contract to supply a unique item, alternate of which is not available in the market. A refused to supply the agreed unique item. What directions could be given to by the court for breach of such contract? Suit for damages. Suit for what? Specific performance. I want that pink car. No other car is there like this. So because it's only one unique item, you cannot pay damages. I entered into contract for that one unique painting. Give me that painting. Suit for specific performance. Suit for specific performance. Damages, if any, you incurred any loss because of this, adirunda you will claim. Okay. Able to follow, guys? Okay. Next, what we'll do, we'll just split as teams in the class, just for you to have some, which side answers first. This first 3 rows is one team, and Hariharan. This side, 1, 2, 3. Jay Shri, your row, and these people are one team. Online also, I will add in this side, because strength is almost similar. Online also one team. So whoever answers first, raise your hand, we'll discuss the answer. Next question number 3. G bought a tweed coat from P. When she used the coat, she got rashes on her skin and skin was abnormally sensitive, as her skin sensitive. But she did not make this fact known to the seller. That is P. Mrs. G filed a case to recover damage. Can she recover damage under Sale of Goods Act? This side, no. Other side, yes or no? Can she recover? We are talking about implied condition as to quality or yes. But inform pannu. You need to inform to the seller, I have sensitive skin, correct? Let's say you go to the shop. If you look at the cosmetic products, they predominantly classify for sensitive skin, normal skin, dry skin, oil skin, different is there. You have some sensitive skin. Can you use all the products? So if you go to shopkeeper, I want to tell you your sensitive skin. He will give what is available. He gave the normal coat. If you have sensitive skin, you have to inform. Implied condition as to quality of fitness. In that one condition, buyer has to inform the seller about the requirements, needs. Inform, did not inform. Can Mrs. G sue? P cannot sue. Are you able to follow, guys? Understanding? Now next, question number 4. Now what I will do for every question, can I give you 15 to 30 seconds? You try next 4, 5. You try it, you read, give me the answer, we'll discuss. Go ahead. Somebody from here. Or you read by yourself. No one to read loudly. Read by yourself. Think it's exam for next 2 hours. Fast we can finish. Those who are watching online live recording also, just read and think of the answer. You are in exam now. Can he exchange the fan, guys? In first case, can he exchange? Yes. Why he can exchange? Because I informed I want table fan. Huh? Ask for exhaust fan, I got table fan. Of course, you can exchange. The shopkeeper, is T right in refusing? He cannot refuse. What is the remedy available for M? Buyer against seller, suit for damages for non-delivery or wrong delivery, suit for price. All those things you can do. Are you able to follow, guys? Next, question number 5. Go through, guys. In previous question, you can sue for price. You can also cancel the contract. One of the remedies is suit for price, cancel the contract, rescind the contract. 5th. Answer guys, this one. Define the meaning of associate company. We have definition. Associate means controls the significant influence and controls the business decisions through an agreement. What is significant influence? At least 20%. Let's look at this. Allotted equity shares of 15 crores and issued non-convertible debentures of 40 crores during the financial year. We don't care about that. After that, paid up share capital of the company is 100 crores and debentures is 120. You are having 15 out of 100. You are having only 15%. You are not an associate company. Are you able to follow, guys? Clear? Associate company means either has significant influence or controls the business decisions. Sometimes I can have only 7%. But if I control the business decisions through an agreement, I become associate. That is also possible. Clear? Next, question number 6. We saw similar question in our class itself, but just quickly go through. Answer guys. Same question we saw. Let me repeat. Here the parties purchase some, what to say, furniture, but after the purchase, P died. After P's death only the furniture was delivered. We discussed it depends on when the furniture is entered in books. If the entry is passed before death, then P's private estate will be liable. If entry is entered after P's death, he is not liable because liability is incurred after his death. As per the RTP, the answer assumption they are taking is what? Entry is passed after death. So liability is incurred after death. In first case, is the estate liable? Not liable. Normally, estate is liable for liabilities up to date of death. Second, does it make any difference if JR Limited supplied furniture to the firm, believing all the three partners were alive? Does it make any difference in that case? Go through, guys. Let me take both scenarios. This is the date of death. This is the date of death. You are supplying furniture for the company. Whether your new partner is dead or alive, still who's buying the goods? Firm. So who's liable? Firm is liable. But if partner is alive, he is also liable. If partner is dead, he is liable until the liability up to date of his death, his estate. So does it make any difference? No, it does not make any difference whether third party is alive or not. If the other parties decide to continue the partnership is still continuing. Are you able to follow, guys? What they are saying, if a partner dies, it leads to death. What happens to the firm? Firm can either continue if other parties agree or the firm will be dissolved. Now, end of the day, in this case, who is buying? JR Limited, the firm ordered JR Limited to supply. Contract is between firm and JR Limited. Partners will keep coming and keep going, correct? What if partner is retired? Will you stop the contract? You will still enter. Same way if partner is dying or if new partner is coming, makes no difference to JR Limited. They will still supply. Who has to bear the liability? Firm. Because order is not done by partner. It's done by the firm. Are you able to follow, guys? Yeshwant, understanding? Yes. Clear? Only if one partner is alive, remaining all died. Then what happens? Firm ceases to exist. Dissolution. but still it's a liability incurred before dissolution. Partners will be liable. Consequence of dissolution. Clear? Next, RTP November 21, question 7. Let me read this if you want. Rahul, a minor, falsely representing his age, enters into an agreement with shopkeeper for loan for purchasing a laptop. He gave expensive watch as security and took a loan of 40,000, falsely representing age. Shopkeeper does not know what. He's a minor. He was very happy to get 40,000 and quickly went to the market and purchased the laptop worth 30,000 and happily spent the rest of his money with his friends on some trip. Later on, Rahul realized that his watch was expensive watch and he should not have given like this to the shopkeeper. So he went back to the shopkeeper and asked for his watch back. Also, he refused to pay the loan amount. The shopkeeper disagrees to this and files a case against the minor for recovery of the loan. Can the shopkeeper succeed in recovering the loan from shopkeeper? Contract in minor is void ab initio from the beginning when the contract was entered. Every void contract benefit has to be restored since he is entered by doing falsely representing, which becomes a fraud. The maximum remedy shopkeeper can get is suing the personal property. He cannot get anything more than that, because in void contract, performance of contract, what we saw, unit 4 la, voidable contract and void contract, benefit should be restored. Here, benefit should be restored by minor, not from his personal money. His property, if any, will be restored. No sir, minor is not having any property. Shopkeeper gets nothing. Are you able to follow, guys? But the main concept is agreement with minor is void ab initio. Clear, guys? Jana following? See, he will, shopkeeper disagrees to this and files a case. Will he get the watch back? Shopkeeper will not get. But he has the right to get it back from personal property. No, both parties. If minor returns the money, he will get the watch back. Yes. See, void contract, na, restoration of benefit. If you are giving the money back, you will get your watch back. Of course, yes. Are you able to follow, guys? No, minor. Yeah, he didn't restore, so he won't get the watch back. If he restores, he will get the watch back. Able to follow, guys? Minor cannot plead minority. Minor can plead minority for escaping criminal proceedings. Let's say minor has taken a loan, is falsely representing. Here is not, see here, he's not giving what to say, loan. He's taking a loan, correct? He gave his watch as security and took a loan of 40,000. When he took a loan of 40,000, for repaying, when the person shopkeeper sues the minor, he can plead minority. He can say, I am a minor, contract is void, I won't pay. That is the concept of pleading minority. If you do a mistake, you can escape by saying what? I am a minor. Here he gave his watch. To get his watch back, he has to give the loan. Are you able to follow, guys? Just remember, if you want, we'll read the answer of RTP November 21 after doing some set of 10 questions. Okay. The answer says, first part of the answer says contract is void ab initio. Second part of the question says the shopkeeper can sue him for the personal property. That means what? If minor has any personal property, he can sue that. That's it. Next. Question number 7. I think it repeated twice, guys. 7, 8, one question now. Minor, falsely representing. Are you able to follow, guys? Let's go to question number 9. Read question number 9 by yourself. Take a minute. I'll show you the answer for previous question also. Let's proceed. 9 Musta, I'll go to 8. Ninth answer. X was a disc jockey at a 5-star bar. As per the contract, he is supposed to perform every weekend, twice a week. X will be paid 1,500 per day. However, after a month, X willfully absents himself from performance. What are they trying to test? Quantum merit. Does hotel have the right to end the contract? Yes. Breach of contract, and yes, they can end the contract. If the hotel sends out mail to X, they are interested to continue the contract and Y accepts. Can hotel rescind the contract after a month on this ground subsequently? No. You had the right to revoke, but then you didn't exercise that right. Again, you sent another offer and they accepted, so you cannot revoke. In which of these cases can the hotel claim damages he suffered loss? Because both the cases. This is in hotel viewpoint. But in disc jockey viewpoint, he can claim compensation in quantum merit. For whatever work I have done, I can claim. Able to follow up. Anybody has a doubt? Now let me go to the previous question, minor question, since some of you had a doubt. I have just downloaded the RTP of that which are may whatever. This is that Rahul question. Let's read the answer. As per section 11, a minor is not competent to enter into a contract. We agreed. An agreement with minor is void ab initio. From the very beginning. When a person forms an agreement with minor, such an agreement is devoid of any legal consequences for the person, because minor cannot be enforced to perform his part of performance in agreement. This part clear? Second part of that question. However, if minor obtains property by fraudulently misrepresenting his age, he can be ordered to restore the property or goods thus obtained. He got the laptop, that will be restored, although no action can be taken against the minor. That means what? You can sue his personal property. That's what we saw. But if any property, other party in his possession, court can order to return, ask him to return the same. That means what are they trying to communicate? Minor cannot be made personally liable, but you can sue the property of the minor. Other second paragraph intention. Third, hence in present case, Rahul is not liable to repay 40,000. Of course, I am pleading minority. I will not repay 40,000 that he has borrowed from the shopkeeper, but he can be ordered by the court to return the laptop to the shopkeeper. But if he returns the laptop, he is returning the laptop to the shopkeeper. Able to follow, guys? But he need not repay the 40. If you repay the 40, you will get back your watch. Void contract. Restoration of benefit. Not for one party. Both the benefits should be restored. Are you following? Upon what defense for minor? Same thing if a major does. Ulla potruvaanga. They will put him in jail. Minor, he will roam around freely. Need not repay. He will not be insolvent. Are you following? Clarified now, guys. The only extra point is that second paragraph. Fraudulent way, personal property. Clear? Liable for tort. Example of liability of tort. If minor makes a mistake, he is not criminally liable, but civil liability. Car, you broke the car glass. Pay compensation from your personal property if anything is there. All of you clear? Understood, guys? We will look at the answers for whichever you feel you have confusion. Ask me if you have a confusion. Don't leave any question as it is. Yes. Third one. In which of the cases can the hotel claim damages it has suffered as a result of breach? First case, they can claim damage. Second case, if hotel sends they are interested, if he accepts, you can't claim damage. But if the hotel rescinds the contract before itself, then they can claim. So here, if the hotel actually accepts, then they cannot claim. Since both are same November 21 RTP, we just have that file open. See, look at this. Same question. Hotel 1, look at the answer. First we saw what? Hotel can end the contract. Second, hotel has the right to continue the contract, but if this right is exercised, they cannot subsequently cancel. You can claim damages in both the cases because you have a loss. I have a loss, you can claim. After this, you are continuing the contract. Now you cannot cancel it. Able to follow, guys? Understanding? Next, Only these two questions are repeated. Same this, I think I copy pasted it twice. After this, rest of the questions are same. Just mark in that book, no Preeti. Just strike it off. After you strike it off over there, I'll understand. After this, nothing else to strike. Everything is perfect. Question number 11. Is it going fast? I will slow down. Let me know. I am okay to stay even till 9 p.m., 8 p.m., 7 p.m. today until we finish these 60 questions. Okay. Next. Ram Lal Birla was a big businessman of city, Pune, having 2 sons and 1 married daughter. He decided to gift his 1 house to his daughter. Dowritana. For this purpose, he called the lawyer at his house and made a written document for such gift. The lawyer advised him to get the transfer document properly registered. When they both were going to go for registration of document, they met with an accident and both died. Later, his daughter found the document and claimed the house on behalf based on this contract. Explain when she get the house as per Indian Contract Act. Go through the question. Can she get? She cannot get. Why? Contract without consideration is, agreement without consideration is void. Agreement without consideration is void. But this is valid if made out of natural love and affection. If such the same thing is in writing, if the same is registered in law. Correct? And gift, with the words used in material is ABC or mnemonic. Completed gift. Is the gift completed here? Promise to give a gift is not valid. But once I give the gift, you suffered loss. Valid. Here, we are focusing on natural love and affection. Writing, yes. Natural love, yes. Father, daughter. Is it registered? On the way, gone. So, does she have the right to get the gift? No. She will not have the right to get, because the document is not registered. Sir, and Purila sir, in movies you will see will. Will is prepared, but court seal wangla, yet to get registered. Is it valid? Not valid. Able to follow? Clear, Hariharan? Question number 11. Simple question. Read it by yourself. One question I'll read, one you read. I want you to be ready for exam. Just read, think of the answer. Wrong also, it's fine. What is this? TQR hospital in Delhi recruits A on a contract basis for 3 months. The hospital man promised to pay lump sum of 1 lakh if D test positive for COVID. COVID time nobody wanted to work. So they are saying, nee work panna. If you become positive, I will pay 1 lakh. What's the point of getting 1 lakh? Life only important. But the question, okay. During the contract period, identify type of contract held. What is it? Contingent. I will pay you if you get COVID. If you don't get COVID, nothing to pay. What will happen if A does not get COVID? Contingent contract, rules of enforcement. Contract is valid on event happening. Contract is valid on event not happening. Here, event happens, valid. Event does not happen, contract is void. That's the next point. It can happen, one separate condition. It happens within fixed time. What will happen if A does not contact COVID? Contract is void. So event does not happen within fixed time, so contract is void. Able to follow, guys? Rules of enforcement, 6 points if you remember, we discussed. Clear? I hope online you guys are following. Keep going. Question 13. Exam 4 to 5 marks. Read, understand, then we'll discuss. I'll give you again 30 seconds. What is the answer, guys? Can Archika recover the amount? What is happening here? Went to jewelry shop and asked shopkeeper to show the gold bangles with white polish. Shopkeeper informed that he has gold bangles with lot of designs but not in white polish. And rather, if Archika select gold bangles in the shop, he will arrange for white polish on these gold bangles without any extra cost. Archika selected set of designer bangles and paid for that. She paid advance or whatever. Shopkeeper requests Archika to come after 2 days for delivery on these bangles. When Archika comes after 2 days to take delivery of bangles, she notices that due to white polishing, the original design got disturbed. Now she wants to avoid the contract. Two cases here. One, we can answer in two perspectives. One, agreement to sell and sell. Is this sale? It's an agreement to sell a good based on what we saw agreement to sell and sale. Sale means ownership is transferred. Agreement to sell, ownership will be transferred on certain conditions being satisfied. Now, agreement to sell becomes sale when conditions are satisfied. Here one condition is what? Polish should be done in the original design. That is done, but original design has been disturbed. So condition not satisfied, ownership is not transferred, sale can be avoided. That is one way to answer. Second way to answer in Sale of Goods Act, he's asking Sale of Goods Act is, in case of specific goods to be put into deliverable state, ownership is transferred after they are put into deliverable state. Here, it is not put into deliverable state because the original design has been disturbed. Will you pay for it? No. You can avoid the contract. She can recover the refund. The buyer can sue. This is RTP November 21. Agreement. Yes. Agreement to sell and specific goods. Both are under Sale of Goods Act. Second case, I'll explain again. What would be your answer if shopkeeper says that he can repair those bangles, but he will charge extra cost for the same? He offered to do it for free. Now he is offering with extra cost. I will not accept. Are you able to follow, guys? RTP November 21. Now, previous questions also are. I can maybe find the answer. To conclude, first case, basically it's a very basic question. We won't expect it to be like that. Agreement to sell says it becomes a sale only after some conditions are satisfied. Here the condition is to polish white paint without damaging bangles. They did not do that. Therefore, a condition failed. It will not become a sale. It is a condition based on facts and circumstances. If you remember, we classified contract of sale into two buckets, correct? Of sale, agreement to sale. I told sale is something where ownership is transferred right now, immediately when sale takes place. Agreement to sell becomes sale after some specified time in case of future goods or after satisfying some conditions. Here in the question, condition is white polish. I'll per se even show the material answer. I don't know which question it is, but it should be in this RTP. Yeah, here Archika found it, guys. Question 7, answer. I'll read the answer, then go to question. On the basis of above provision, the facts given in question, it can be said that there is an agreement to sell between Archika and shopkeeper and not a sale. Even payment was made by Archika. The property and goods can be transferred only after the fulfillment of conditions fixed between them. Since condition is not fulfilled, you can avoid the contract. Second, on the other hand, if shopkeeper brings with extra charge, he cannot recover extra charge from Archika. Even he has to bear some expense for repair, he cannot charge it to Archika. They are not writing about deliverable state. That can also be added because goods are not in deliverable state. Able to follow, guys? Under sale. Sure, put it up. Next question number 14. Some sweet example. Yes, go through by yourself. Out of 60 questions, even if you get 40 correct, feel happy about it. Don't expect, sir, I want all 60 correct varnu, sir. Na parchakod it will not come. When I take, if someone gives me 60 questions, if I read, honestly for me also 50 only will come correct. Sometimes you will miss the concept. Being very honest, any faculty for that matter. Illa sir, 60 out of 60 faculty got correct. First one, he studied yesterday and he came. That's why it's correct. Are you able to follow, guys? Any faculty, one advice which I got from my seniors when I started teaching 5 years back or something, I advise, even 30-year-old faculty to whom I used to go, everyone follows one thing. I want to tell one truth. Okay. No faculty might reveal that. Okay. Whether you are a fresher faculty, 5 years experience, 30 years experience, or 40 years experience, nobody can come and teach just like that. Nobody will teach. Every faculty will revise before the class. They won't revise for 4-5 hours, 120 minutes. For a 4 hours class, 20-30 minutes, quickly go through the notes. Sir, I'm fresher, sir. 4 hours class, 4 hours preparation. It's as simple. Even a faculty with 30 years, 35 years, senior faculties have told me one advice. Before you go to class, revise and go. How cricketers, before match, even if it is Sachin, he's going to practice before the game. Everybody will do it, but we will not tell. Why? Then the faculty cannot show off, no. Hey, I know all this. Nobody will remember, guys. Everybody are humans. But just at the time of revision is 5 minutes. If I have to revise Sale of Goods Act tomorrow, I will take a class full day. I need 10 minutes to revise. I will come and take the full 4 units. Do you get it? So everybody will revise. If I revise these 60 questions and come, I can give all the answers. Some I may make mistakes, but I will ensure I don't make the mistake. Are you able to follow, guys? That's the whole point. Now question number 14. Read it. So I don't want you to worry. Out of 60, I'm getting only 40 correct, sir. It's fine. It's normal. Go ahead. Read question 14. What is the answer, guys? Implied condition, sale by sample or as well as description. Here they are saying Prashant went to sweet shop, ordered for 1 kg of barfi. If the sweets are fresh, he first taste 1 piece of barfi to check the quality. Then seller gives him a piece of taste. So after that, Prashant is saying quality is good. He purchased. Later, quality is not good. Can he avoid? Yes, because sale by sample is not matching with bulk. What if he is not tasting? He is not tasting. Sale by sample la varadu. Mercantile quality is not for food, for other products. Here, either you can write wholesomeness or sale by description. What description I asked for? Barfi sweets are fresh. Shopkeeper told sweets are fresh. Description matched. Actual good is not matching. So first point I'll write sample. Second point I'll write description. Plus you can write, yes, sample as well as description. Sample plus description. Second is what? Description. Wholesomeness, additionally you can write. That is not the only answer. Wholesomeness in the same 1 kg, 100 grams எடுத்துட்டோம். பாதி சாப்பிட்டு வச்சிட்டோம். One piece he ate half and kept. Not wholesome. Will you take 1 kg of barfi you bought? 1 piece alone I am biting and keeping. Shopkeeper is keeping. 1 piece dana sir. Take it. Will you take, guys? Wholesome. Are you able to follow, guys? Sorry? Where? Would your answer be different? Yes, answer will be same. In both cases, Prashant can avoid the contract. First case, implied condition as to sample and description. Second case, implied condition as to description. Can I add wholesomeness? Additionally, you add. That is not the only answer. I remember the answer for this ICAS material. They don't have wholesomeness in that. But you can add it additionally. Are you able to follow, guys? Clear? Flask. I purchased this flask for 1200 rupees. For what purpose? Online also I will show. What purpose? Water to be hot. Cold water put, water should be cold. I am going in the break and filling hot water and coming. Half an hour it's becoming cool. Is there any use for flask? I can buy one Tupperware plastic water bottle. Mercantile quality, not mercantability. It's not used for the purpose. Are you able to follow? I purchased clock. It should show me time. Every 2 hours, battery maatnun solra. Not mercantile. It is not solving the purpose of which you purchased itself. Are you following? You bought towel to clean the table to absorb water. They are saying this towel will not absorb water. Waterproof towel and solra. Not mercantile. Are you following? Otherwise, waterproof towel is there. Waterproof t-shirt towel is there. Where if you wear rain, nothing will happen. Waterproof shoes, pant, all that. Okay. Recently, I saw one startup which launched a t-shirt, normal shirt or t-shirt what you are wearing, where if you fall in the water, you will float. Shirt that can float. It's a life jacket with shirt. Purira. The quality is such that it's a kids brand, mainly for kids. So kids can wear this t-shirt and shirt and go anywhere. If they fall in the water, nothing will happen. They will float. Are you able to follow? They got good funding. 10 kodi, no, some 10 million is invested in the company. 10 million is equal to 80 crores in dollars. So 10 million US dollars somebody invested. 80 crores investment. An idea. Shirt la life jacket. That's it. Okay. But you should get that idea, no? Correct. Email on the price, no? They got the patent also. Nobody can copy. That's it. Next. Question 15. Yes. What's the answer? Is he liable to pay? Akash purchased a television from Jeet Lal. Jeet Lal is seller, Akash is buyer. The owner of Gada Electronics, on the condition that the first 3 days he will check its quality. If satisfied, he will pay for it. Otherwise, return the television set. Sale or return basis, approval basis. On the second day, television set was spoiled due to an earthquake. Jeet Lal demands the price from Akash. Whether Akash is liable to pay. Is he liable to pay? Yes. Is he liable to pay? Now, 3 conditions. You give the consent, you don't give the consent, or you keep the good beyond reasonable time, or does something with the good which is equivalent to acceptance. You tell me common sense answer. If you are Jeet Lal, will you allow? If you are the seller, will you say, okay, paravala, earthquake, leave it? You will claim the money. That's all. Does something with the good equivalent to acceptance. But here, the good is spoiled not because of fault of seller or buyer. You cannot say Unit 1 of Sale of Goods Act contract will become void, benefit cannot be given. Now, what is the answer? Demands the price resolution from Akash, whether Akash is liable to pay the price under sale of goods. No. 1 second, let me think. This is sale or return basis. Ownership is transferred in first case if you accept. We are seeing about who has the risk, correct? Ownership is transferred if the acceptance is given, or second, keeps it beyond reasonable time. Here time is 3 days, only second day, so not even beyond reasonable time. Third case, the buyer does something to the goods which is equivalent to acceptance. Here, buyer is not doing anything. It's happening by nature. So, buyer is not doing anything. Therefore, is the ownership transferring? No. So, is he liable? No. He is not liable. Correct. If not, who will ultimately bear the loss? The seller will bear the loss. I just want to double check the answer in the material, so I'm going and checking once, guys. Here it is, question 8, I think this only. Akan Sheetlala. Yeah, loss has to be finally borne by Jeetlal because sale or return basis, ownership is, property is not passed to. English is wrong, guys. RTP, they are saying property is not passes to Akash. Exam. Are you able to follow? Property is not passed to Akash. Are you able to follow? You are correct, Subhadra. Ownership is not transferred, so risk is going to be with the seller. Able to follow, guys? Understanding? So many RTP November 21 protocol. Everything is there. Actually, everything is there. Nothing. Yeah. Yeah. Go through question number 16. Read the question, guys. Take a minute. Read process. Should the profit be returned? Yes. A partner should not make secret profits. If you make the profit, return it back to the firm. Keeping this as reason, can I expel the partner? The reason of which can I, who's the person? B. Can I expel B? Can A and C expel B? Yes. If it's provided in the contract terms and conditions, it's in good faith, everything is satisfied, yes. Now you didn't do, what is the proof? Now you did it, what is the proof you won't do it next time? He can be expelled, not a question, but I'm asking. So here secret profits should be returned. Are you able to follow? Understanding, guys? What is the secret profit? Extra how much, guys? 150. I'll explain this. It assumes there's no contract. Huh? I'll explain. So what he's saying, first I'll explain this. Assume there is no contract between the partners. அவங்க என்ன சொல்றாங்க? B சொல்றான். நீ எனக்கு சொல்லவே இல்லையே. You never informed me that I should not make secret profit. It is not there in the partnership deed that if I make secret profit, you have to return it. Are you able to follow? Is it necessary for that to be in contract? No. It's all, if it's not there in deed, act provision will override. Able to follow? That is, there is no contract between the parties. Above that, the other doubt is, he supplied iron bars without firm realizing the purchase cost. Is B liable to pay extra money he made, or doesn't he have to inform the firm? He's saying the second business he has, he's not informing the firm. Secret profit is adana. Secret, you will not inform. Of course, you will return the profit. What if he informed? Then other partners would have given the consent. Then it's no more secret profit. Are you able to follow? Understanding? Clear? What is the difference, guys? 150 rupees per kg into 1000 kg is the amount of secret profit. Current market 50 and already correct, but that profit should have belonged to the firm, no? Why is he selling it outside? Correct. I'll explain. அவன் என்ன பண்ணிருக்கான்? What he has done, he knew that the market price is going to go to 350. Before itself he purchased and kept for 200. Now he is selling to the firm for 350. Correct? Can you do that to the firm? Correct. But he is the partner of the firm. Partners have that mutual trust. Correct? You cannot make profits with the firm itself. That too in this way. Genuine transaction you can do it. This side clear? Next question, November 21. Yes, go through, have a read. Okay. Transferee is the new partner. A is the transfers his share in a partnership firm to transfer of interest. Subpartner. Correct. A transfers his share in partnership firm to B. B felt that the books of accounts was displaying. No, this is transfer of interest means his share. If you say 1/3, in that share he is transferring to B. The transferee B only has the right to receive the share of profit. Can he interfere in the conduct of business management? No. Can he participate in other activities of business? No. Can he inspect books of accounts? No. Only you can get the share of profit. Are you able to follow, guys? I think section number 29 or 28 should be same RTP. So let me just check it once. It should be somewhere here. Yeah, this one. Transfer is not having right to. Transfer is not entitled to interfere with conduct of business, require the books or inspect the books of the firm. He can only get the profits, entitled to share the profits. Next, can you see both the question 18, 19 together, guys? 18 and 19. Try to solve it. Try to solve it. Yes. Same, huh? I basically made one student paste the questions from here. So leave it. Just strike it off in the book. Strike it off in the book. Just do 18. Sorry, guys. So effectively, we'll be solving 55 questions. Okay. Go through. Hello, should they be dissolving it? Yes. In third unit of partnership, when dissolution of firm by intervention of court, where the business becomes unlawful or illegal. One line of business manufacturing Ajinomoto. Contract Act. Consideration unlawful in part. One contract valid, one contract void. So here, this is the whole business partnership as the whole, correct? So Ajinomoto, one find a law is passed banning use of Ajinomoto in foods. See, if you can close the Ajinomoto business, then you can continue the other thing. Otherwise, you have to dissolve the entire firm. Since it's RTP November 21, it's ready. Let me just cross check. It can continue the other part. Let me just check that. Here is the answer. Yeah, here is the answer, guys. 41, dissolution. Firm has to be dissolved when however, where there is more than one separate adventure or undertaking is carried on, illegality of one or more shall not itself cause the dissolution of the firm in respect of its unlawful. Yeah, exactly. See what they have mentioned here. See, read this paragraph. Here, MN has to compulsorily dissolve due to happening of law which bans the usage of Ajinomoto. Else the business of the firm shall be treated as unlawful. Now, they are saying, of course, this will not affect the other business. If you close what? Ajinomoto. Look at the point. However, where more than one separate adventure undertaking is carried on by the firm, illegality of one or more shall not cause itself dissolution of the firm in respect of its lawful adventures. The implication is you have to shut down what? Ajinomoto business. If you don't shut down Ajinomoto business, can I continue other one? No. Understanding the point of, if you shut down Ajinomoto, business can continue. If you don't shut down Ajinomoto, close the whole business. That's what they're trying to communicate. Illegality of Ajinomoto will not affect the legality of other business. Are you able to follow, guys? Next, same repetition. Question 20. I think about government company. Read it. RTP question, guys. Read. Answer, guys. Look at, let's draw a chart. Narendra Motors is a government company. Shah Auto Private Limited is a Shah is a private company having 10 crore shares, 10 lakhs into 10. Narendra Motors is having how much? 5 lakh, 5,000. That means more than 50. But is it, we should have how much? 51% of paid up share capital. So you divide 5 lakh 5,000 divided by 10 lakhs. How much is coming? 5 lakh 5 divided by 10 lakhs. Exactly. 50.5. Is it 51? So is it a government company? No. What is government company? A government company is a government company if not less than 51% of paid up share capital is held by. So where students will get confused. Sir, more than 50, sir, it becomes government. More than 50 becomes holding subsidiary, but not government company. Are you able to follow, guys? Look how beautifully they drafted the question. Correct of 50 ko 51 nadula vandiru. So those who remember 51 will say it is not a government. But otherwise you will say what? It is a government because it's more than 50%. Able to follow, guys? No, holding company, the definition is controls more than half of the total voting power. That's more than half. Even 50.1 becomes holding. That's the difference. Holding subsidiary. Able to follow, guys. Go to the question. Last question of RTP, November 21. There are more questions, but I've taken only key questions. Okay, go through. Answer, guys. Lifting of corporate wheel, saying that Dhruv and the company are one and the same. Are able to follow, guys? Yes. I'll just read that. Correct. Here, what is the contract? Dhruv and Sun Moon Timber Limited were in job. Condition that if he has to leave employment, he should not take the clients of Sun Moon Timber Private Limited. This is how do I put this? You are working in Infosys. Infosys is saying if you leave Infosys, you can leave, but don't take our clients and go. That's a normal expectation now. It was very hard to find the clients. You cannot take them. So what Dhruv, if you do that, we will sue you. So what Dhruv did, he started one more company called Undercut Sun Moon Private Limited. Sorry, he undercut Sun Moon on the legal advice 7-star Timbers. So he gave for the same service for lower price. Undercut na he gave for discount in the name of 7 stars. Later company, when they sued them, they found out basically it's the same person. Dhruv cannot tell I am not doing this work. 7 stars Timbers is doing. Lifting of corporate wheel, both are one and the same. Avoid legal obligation is one, or fraudulent for fraudulent purpose, to defraud our parties. You can write. Clear, guys? Next, question 22. Go through it. In essence, over here you can write protection of revenue tax will not come. Formation of subsidiary to act as agent also will not come. Either you can write defraud or legal obligation. What is the legal obligation? Dhruv has a legal obligation to protect him from that. Okay. Next. The same provision what she told earlier. There are two contracts in this. One is seller's house, legal. Other is gambling, unlawful. If you can split the contract, the lawful one will be valid, unlawful will be void. No sir, I cannot split. Then the whole thing will become void. Here, can I split? Yes. So he started gambling business in that house. Can A claim 50 discuss? So the house rent agreement is so sale of house is a valid contract, but gambling activity is illegal, therefore it becomes void agreement. Are you all able to follow, guys? Understanding? Next. Go through the question. Read. Take a minute time. You're in exam. Read, get the answer. That's all. You can claim for damages. We have two types of damages, general or ordinary or special damages. Special damages can be claimed only if you inform the party about special circumstance. Here, clear kuduthirukam. He did not bring the notice of this fact to the railway authorities. Special circumstance not communicated. So she can claim damages, ordinary or general damages, but not special damage. She cannot claim this exceptional profit. Able to follow? Clear, guys? Purida. Next. Let me read this. Mr. Asim is a learned advocate. His car was stolen from his house. He gave an advertisement in the newspaper that he will give a reward of 10,000 to anyone who gives information about his car. Vikram reads the advertisement and on making some efforts got the stolen car and informed Asim. Asim found his car but denied giving reward of 10,000 to Vikram on the words that an advertisement in newspaper is just an invitation to offer and not an offer. Hence, he is not liable to make the reward. What is the answer? It is a general offer, so you will accept and pay. But look at the RTP answer. If sometimes if ICA wants to trouble us, they can trouble us like this. May 22. Seema, this is done. AB. Fourth question. Everybody will write general offer. Nanu adena eldirpa. General offer. But look at the answer given by ICA. An invitation to offer is different from offer. Quotations, menu card, price tags, etc. for sale are not an offer. These are merely inviting public to make an offer. Invitation to offer is an act precedent to making an offer. Fine. Acceptance of an invitation to offer does not result in contraction or any, only an offer emerges in process of negotiation. But there is an exception to above provision. When advertisement in newspaper is made for a reward, it becomes a general offer. On the basis of above provisions and fact, can be said advertisement made us. So he is liable to pay 10,000. Reason is, now, what they are trying to say here is, it's not an exception. Newspaper, I'll explain why they are saying it's an exception. Newspaper says job application. You have to apply for it, then they will accept. Newspaper job application is invitation to offer. Me applying is an offer. Here he is accepting. Newspaper reward for missing things. Here, will you tell him I am going to go and search? If you find, you will go and inform to him. So there is one breakage of communication. So here this is deemed to be an general offer. General offer made to anybody. Anybody can accept because here I am not taking the permission of the person giving offer. Shall I go find the car? Shall I find the dog? You are offering, immediately there is acceptance. Why we are discussing this? Everybody will learn in the exam what? General offer, acceptance. But you have not written the words of invitation to offer is different from offer because generally in the question the answer not relevant. Even in the book it's classified differently, correct? For that reason I just wanted to show you the answer. Able to follow, guys? Bookla, is it given anywhere that exception to invitation to offer is newspaper ad? Engel Kurturkana? No. So for that purpose, I just wanted to show you the answer. It is not per se exception in the act. It's just a concept. General offer acceptance. Clear, guys? Next. Question 25. Yes, read it. Can he claim, guys? Undue influence. He is saying doctor agreed to treat him on a condition that Chandan had to sign a promissory note of 5,000 payable to doctor. Chandan agreed and signed it. On recovering from disease, Chandan refused to pay the promissory note. Can he recover? No, because this is what I'm saying. I will treat you only if you pay extra. Coercion, free consent is not there. One is what legally bound to perform. Also, you can write. One is what legally is bound. See here, but he is forcing him to sign the promissory note. My question is, can he recover the 300? 300 can he recover? Yes. That is the consideration in the contract. I will write both the concepts. Consideration is for one is what legally bound to perform. Plus you can also write undue influence. Contract becomes voidable. Are you able to follow, guys? RTP I should check. இதாவது ஒன்று கொடுத்துருப்போம். I think it's this RTP only, no? Third question now. Yeah, in RTP they have given Junjunwala undue influence கொடுத்திருக்கோம். But can you write where is undue influence? I just saw it. Yeah, here. This side. Undue influence. And question, sir, how do I decide whether it is undue influence or other thing? Here, yeah, fiduciary relationship, undue influence, I can write performance of what one is legally bound to perform. Are you able to follow, guys? But that point will come more relevant when if the doctor tells, if you recover, pay me 5,000. If you don't recover, pay me 300. Then that point will come more stronger. Now, undue influence will be a more stronger concept. Able to follow, guys? Next. No, here the aggrieved party Chandan will not pay anything. Doctor cannot recover anything. If Chandan wants, he can pay. Voidable is the option of Chandan. No, if he does not cancel also, see, by not paying, he is rescinding the contract. By not paying is the action of rescinding contract. 26 we did in the class, but still let's do it one more time. This only we dictated and wrote in the class, guys. Now dictate panana nyabam iruka. Just do a quick read. I dictated an answer for this. Just do a quick read and give me the answer. You already? Yeah, I know, but I just wanted to quickly revise once. Answer, guys. Okay, take another minute, read. Online recording, everybody read it, guys. No problem. We have sufficient time. Easily before 7:30, we will finish. Much advance. Yes, she'll get the money. I'll put in the group. I have it ready. I'll just forward in the group. When you're reading next question, I'll do it. Answer, guys, for this. Same implied condition, quality or fitness by usage, where the buyer specifies the specific use of the good and seller deals in that same good, then buyer is liable to rescind the contract. Here, buyer specifically சொல்லிருக்காங்க, I want what? Saree for daughter, it should be cotton silk saree, but seller gave what, guys? Some organ dye material. Therefore, even though seller is dealing in cotton silk and I requested for it, you didn't give that, implied condition. Therefore, here exception to caveat emptor, let the buyer be like exception, seller is liable. We dictated the answer also. For those who missed the class, I am doing a quick revision. Anybody wants me to repeat, I will repeat. Anyone? I will draw and show the answer. Fine. Next. Question 27, guys. Go through the question fast. Is the sale valid? What's happening? A went to B's shop and selected some jewelry. He falsely represented himself to be a man of credit and thereby persuaded B to take the payment by check. He further requested him to hand over the particular type of ring immediately. On the due date, the seller B presented the check for payment. Check was found to be dishonored, breach of contract. Before B could avoid the contract on the ground of fraud by A sold the ring to C, buyer in possession of goods before sale. C had taken the ring in good faith without any notice of the fact that goods with A were under voidable contract. Discuss if such is valid or not. It is valid, yes. Nemo dat quod non habet. One of the exceptions. Sale by a person under possession in voidable contract. You can also fraud. Voidable. Coercion, undue influence, fraud, misrepresentation, free consent not there, voidable. Mistake, we have the different cases. Able to follow, guys. You can also write buyer in possession of goods before sale makes the sale. We have some conditions. Party is buying in good faith. He does not know it's a voidable contract. He has no notice of the previous sale. Then who will get good faith, good title? He will get good title. Able to follow, guys. To quickly show you the conditions. Yeah, these are the conditions, guys. Possession under voidable contract. Person has possession under voidable contract. Yes, A has that. The contract has not been rescinded or avoided. Correct. B did not cancel the contract yet. The person having possession sells it to a buyer. Buyer buys in good faith. Yes. Buyer has no knowledge that seller has no right to sell. All conditions met. Therefore, sale is valid. Do 28 and 29, guys. Take a minute time. Go through both. Think of the answer. Sorry, 29 you cannot do. Just do 28. Do 28. Can he claim? Normally, remuneration is decided in the agreement, partnership deal. Here, they don't have an express agreement in partnership. But when you are paying to other partners, it becomes an implied understanding, orally agreed, that remuneration is paid to other partners. So, unless you expressly tell new partner will not get remuneration, all partners have rights. So, new partner will have to get paid for remuneration. Able to follow, guys? If you want to read the answer, eleven, no? No, not 11. 12. Yeah, 12 is the answer. By virtue of 13A, a partner is not entitled to receive remuneration for taking part in conduct of business, but this rule can always be varied by an express agreement. Because generally, remuneration, if deal is silent, no remuneration. Correct? In which event the partner will be entitled to remuneration, thus a partner can claim remuneration even in absence of a contract when such remuneration is payable under the continued usage of the firm. Basically, if others are being paid, I can also get paid. Yeah, able to follow, guys? 29. Let's read here first. XYZ and Co is a part and company is a partnership firm. The firm is a unregistered firm. The firm has purchased some iron rods from other partnership firm LM & Co, which is also an two unregistered firm dealing with each other. In the eyes of law, I cannot see both of you. XYZ could not pay the price within time as decided. LM & Co filed a suit against XYZ for recovery of price, state with provision. Can they file a suit? No. What would be your answer in case if XYZ is a registered firm while LM is an unregistered firm? Still cannot sue. What would be your answer if XYZ is unregistered, LM is registered? Can sue. LM, who wants to file a suit? LM wants to file suit. Whoever is registered, law can see them only. So in the second case, XYZ is registered, but LM is not registered. So LM is wanting to file a suit. When you go to file a suit in court, court will tell I can't see you. But same thing if XYZ is also unregistered, but LM is registered. LM wants to file a suit, I can see you. Give me the case. Against whom? Now I can see that party also. Are you able to follow, guys? Understanding? Clear, guys? Question number 30. Go ahead. Mark the answers in book. Wherever know the answers, revise. That's it. Private company limit you have to check. That's all. Take your time. After this, no need to revise RTP. Answer, guys. First case, should I reduce? Yes. Second case, no. Let me show you timeline quickly. The timeline given is 1st April 2006. 2, they were in employment from 1st April to 28th June. Basically, in this period, if you got the shares, don't need to count. They got the shares when? 1st July 2007. No need to count. They sold it on by them on 1st August 2016. After they left the company, they sold it. Fine, no problem. After some time on 1st December, each of them again purchased shares. Now they are buying shares after leaving the company. Now are you employee? No, so you are somebody else. You purchased it. Now they are asking they want to convert to private company. Can they convert? No, because 220 members includes everybody who purchased it. You purchased it on which day? 1st December 16, which is after you left the job. Therefore, I will count you for the purpose of 200. Therefore, first case, should I reduce? Yes. Second case, what would be your answer? If they were employees from 1st April 2006 till 2017, that means what? Still employees. When I am employee, I sold, bought. So it's fine. I will not count them for 200. Therefore, no need to reduce. Are you able to follow, guys? Sure, 100%. Behind Arvind. I'll explain. If you have a doubt, you just ask me. That's it. 1st April 2006 to 31st July 2016. These 25 employees were there. They got shares on 1st July 2006. They sold it on when, guys? 1st August 2016. They left job when? 31st July 2016. So on this day, they are no more employees. This day they sold it. No problem. Again they are buying it when? 1st December 2016. When they bought the shares on this day, are they employees of company? No. So that means employee of the company did not buy the shares. The existing 220 members who have shares are not employees. So should I, if public wants to convert to private, you should have less than 200. So kami pannu. Later avana solran, what if they were employees till 2017? That means for the entire period of buying and selling, they are employees. So employees the count panniya 200 la count panna maatan. So I will not include. So I have only 195 members. Therefore, no need to reduce. Are you able to follow? Shura Purida, 100% Pavan. Okay. Able to follow, guys? Understanding? Question number 31. Yes. Go through the question. When you don't follow conditions in section 8, government can order for 3 things. Order for winding up, order for merging with some other section 8 company with similar objects, or change the management, or convert section 8 to private or public limited company. These are the solutions. Straightforward, direct question. Now I want you to understand, guys, I have taken only those questions that are difficult or which needs you to think a little more. Straightforward question adikla. Your entire 60 marks will not be like this. Maybe 2 or 3 questions will be like this. If you look at the past exam papers, very, very easy. So I don't want you to lose morale or confidence looking at sir will. RTP generally is 2 levels above exam question paper. RTP na adda. RTP in foundation is same, inter is same, final is same. If exam standards are here, RTP will be here. That's how RTP questions are drafted. If you scroll down to some more questions later down. I would have given exam questions from 48. Easier. Where are the difficult questions in exam? I was not able to follow, guys. So exam is easy. RTP is the difficult one. Okay. Come back to question 32. Go through the question, guys. Simple one. Where subject matter of the contract is dead before entering into contract, then the contract becomes void. It becomes what, guys? Void. Not valid for sure, not voidable also. Subject matter illa. Contract cannot be entered, performed, void. Then no continuation. Yeah, read this. Question 33. First one is what, guys? Undue influence, student teacher. Simple question. A student was induced by a teacher to sell his brand new bike. Undue influence. Second, state cases where there is vindictive or marriage contract or check or negotiable instrument, dishonor of credit worthiness, wrongful dishonor of, yeah, and the credit worthiness of this, and first marriage feelings. 2 points only. You cannot quantify the loss. Are you able to follow, guys? So the court will tell, pay 1 crore compensation on the mic. RTP number 22, next 34. First one is what? You bought cake. Cake has wholesomeness. What are rights available to buyer? Wholesomeness is not there. You can sue for damages, sue for price, not sue for price. Price na cake na 100 rupees irukum. You can sue for the damages, whatever you are suffering. This relates to wholesomeness. Yes, I am giving you pizza. See, wholesomeness comes for food. Is it eatable? No, wholesomeness. See, quality or fitness comes for every product. Buying sari in that example, buying any product like tailor. Food is specific na wholesomeness na avane kuduthirukam book la. What is saying, when something is not mercantile and it's food item, it becomes perishable products, quality is not there, becomes wholesome. Able to follow? I can download the RTP November 22 if you guys want to see the answer. Sixth one. Wholesomeness. He can recover the damages. Of course, mercantile and wholesomeness same na varum for food. Wholesomeness is nothing but goods are not maintaining mercantile quality plus food now wholesome. Yes, it includes both. In simple, if goods are not meeting the specification, it's not mercantile. That means cannot be used for the purpose. If it's a food item, it becomes mercantile plus wholesome. Second part. A contract with B to buy 50 chairs. He delivers 25 of the time and upon 25 of some other type. What you should do? Sale of goods like Unit 3. Rules of delivery. Delivery of wrong quantity. You can accept 25 and reject the balance. And also description here is not met. you have the right to cancel the contract. Let's quickly look. Sorry. You can write both. Here description, where is it? Delivery of, same, they wrote both. Delivery of different description, where seller delivers to the buyer. He contracts to sell mixed goods with different description, not included in the contract. Buyer may accept the whole in accordance with the contract or reject the whole. A may accept 25 shares of the type and reject other 25. Or he may even reject all the 50. Rules of delivery, delivery of wrong quantity. He can accept the whole. Accept all 50, reject all 50, accept 25 and reject 25. My choice. Give all the three options. Mark this as important for upcoming exam. Rules of delivery they have never tested in any of the exams. Okay. Next. Simple question, guys. Quickly read question 35. Can Ankit return the pen? Normally, yes. But here, clear a question or he's trying to deviate you, not deviate you, trying to take you to the answer. It is mentioned blue ink pen. Ankit ignores. Ange kanuputsurnu. Caveat emptor. Let the buyer beware. You didn't check properly. Therefore, you cannot blame the seller. Can Ankit return, guys? Ankit cannot return. Are you guys able to follow? Understanding, Arvind? Thorough understanding of. If you feel it's fast, let me know. We have more 2 hours. I think we'll finish in advance itself. But end of the day, it's revision. Sir, this question can you explain in detail? I will go there and explain. I can even be slow. I'm being fast for a reason. If you're not understanding, feel free to ask, including online students. Are you guys there first? No, everybody left. Now, Google Meet. Okay. Anyway, online, it's being recorded. So, next to question number. Okay, that means question is repeated in RTP also. Are you able to follow, guys? It's repeated in RTP. Basically, what I did, I went through RTPs, marked a few questions and sent to the student to just collate it. This I would have seen it twice on 2 different days. So, repeat it, we just now saw. So, same question repeating in RTP. That means, important question. 2 RTPs are repeated, May 22 and November 22. No, I'm not joking. Every exam of 100 marks, 10 to 15 marks comes from last 4 to 5 RTPs. I can easily tell that for foundation because RTP covers a lot of things. Last 4 to 5 RTPs per se, 20 marks in law, I can guarantee. It covers almost all the concepts. Okay. RTP, they will always ask question. Latest lende kekka maatam. Palaya RTP lende ipo keppom. Okay. Next, RTP, November 22. Go ahead. So what is happening here? No Limit Private is an unlimited company having share capital of 10 lakhs. One of the creditors filed a suit against shareholder to pay the debt. Company na limited liability only. Unlimited liability means when it's liability unlimited. When company is closing down, winding up, in my balance sheet, if liability is more than asset, that time shareholder will pay the difference. Not for day-to-day course. Able to follow, guys. So here you anyway filed a suit. Court, innocent has given his plea that he is not liable, he is just the shareholder. Will Samuel be successful? Samuel has to sue for insolvency. Only when company goes into winding up, they will pay the money. In the case if company cannot pay this 10 lakhs, court will order for winding up. That's the whole point. When you can't pay 10 lakhs, if my liability is more than assets. But what you have to write, shareholder is not liable. He is liable only in the case of winding up of the company. Are you following, guys? Anybody wants me to repeat? Yes. I'll have to search where it is. In the RTP, no? Are we in November 22? Yeah, here is the answer. Readable. Sorry, yeah, I'm just checking. Yeah. Provides unlimited company means a company not having limit on liability of members. True, that's correct. But liability of each member extends to whole amount of the company's debts and liabilities, but will be entitled to claim from other members. Yes, in case of company has share capital, the article states unpaid amount, all of that. They are trying to say, so long as the company is going concern, you will not pay. The creditors can institute proceedings for winding up. You can sue for winding up. The official liquidator may call the members for contribution, which can be unlimited. At the time of winding up, you have to pay on the basis of above. First, he wrote the provision. Now, analysis and conclusion. It can be said that Samuel cannot directly claim his dues against the company from shareholder. No, he can even Innocent, the shareholder of the company, even the company is an unlimited company. Innocent is liable up to his share capital. His liability is unlimited liability will arise only when the liquidator calls the members to pay the liabilities at the time of winding up of the company. Able to follow, guys. That's the same thing in partnership. In partnership also, partner will contribute. During the course of business, partner will somehow pay. If the partner is not able to pay, firm is not able to pay, then we will order for dissolution. Continuous losses, liabilities are more than assets. Able to follow, guys. Go to the question quickly. 38. Nominal partner, answer, guys. Is he liable? Yes. Liable for what? Liable to third party. Will Bohan be liable even then? In case Karan filed a suit against him, is Bohan liable? Yes, still liable to third parties. Bohan cannot tell I am a nominal partner, only share of profits. We saw nominal partner, even though whatever partner you are always liable to third parties. Question number 39. Go through, guys. According to Harish owes payment of 3 bills to Ashish, appropriation of payment. On 31st March 2022, 12,000 which is due in May 2018. That is the first one. 5650 due in August. Second, 9650 which is due in May. Third, order kurthirkan. Harish made 1st April without any notice. How to appropriate in the order of? How do you appropriate, guys? 9680. First you will appoint which one? Which one, guys? First. Without any notice. Why not the previous ones? No. See, there are three provisions here. One, if the parties, if Ashish tells something, Harish owes, Harish made payment. If Harish tells you adjust in that, then I will adjust in that. If Harish is not telling anything, then Ashish will adjust in his own way. If both are silent, order of time. We will adjust in order of time if without giving any notice. But here if you see 9680, 5650 and 12,120. Is there any time bar debt here? Because we can't assume, because time bar debt is not 3 years. State by state it will change. So unless question mentions something is time bar, you don't assume it to be time bar. That is rule number 1. Second, you are paying 9680. Usually I will adjust the first loan of 12,120. But you are not giving any notice. But the amount of 9680 is an implied communication to what? Adjust against 9680. Both are matching. So I will adjust with 9680. Next you are paying. Is there any other loan for 15,000? No. So first you will adjust with 12,000 and balance with 5650, not fully, to the extent available. Are you able to follow, guys? Understanding, guys? Hello? This is the latest RTP, your exam RTP. Okay, June 2023. So I'll repeat 9680, even though he has not communicated. By sending 9680, it's implied that he has to adjust with 9680. Second one did not communicate anything. So 15,000 adjust with 12,120 and then balance remaining amount with 5650. Following. Go through the question. Can Mukund recover from Parth? Parth is the minor. So minor you cannot recover from minor. Can he recover from Naman? Naman is the third party who is buying in good faith from the agent. Sale by mercantile agent, if the conditions are satisfied, sale is valid. Therefore, what Mukund can do? Indian Contract Act. See, Indian Contract Act, even in that case, Naman purchased in good faith of. That only I am just saying. Answer you both understood. Everybody understood. First is, can he recover from Parth? No. Can he recover from Naman? No. Third party. But Indian contract, let's see the RTP, how he is given it. Okay, in Indian Contract Act, there is minor provision which says minor can be an agent. In that paragraph is given, when minor is an agent, minor cannot be liable to the principal and third party gets what to say, the contract entered with third party as a minor agent is valid. We can use that provision only, but let's see what they have done. Mostly it should be that provision. Question 4. They were just saying he got a good title purchased in good faith. Reason kudukla, minor is disqualified from contract with minor is void amnesty, but minor can act as an agent. He will not be liable to principal for his acts. That principle only, section 11, that principle. In instant case, Mukund appoints Parth as minor to sell his car. Clearly instant Parth sold the car to Naman for 1,50,000. Able to follow, guys? Next one, go through that. There are 3 types of delivery: actual, symbolic, and constructive. Here, Kishore confirmed that Avyak can take delivery of wheat from him and he is holding wheat on behalf of Avyak. This becomes what? Constructive delivery. So ownership is transferred. Whether Avyak is right in view and sale of goods act? No. Once it's priced, he cannot get it. Able to follow, guys? Understanding? Pawan following? Sure. Latest RTP, guys, your exam RTP. Read the question, go through. So follow, Priyansh orders an iron window to a iron merchant for his new house. Iron merchant sends his technician to take size of the windows. Technician comes at the site and takes size of area where window is to be fitted. Afterwards, iron merchant on discussion with technician intimates Priyansh's cost will be 5,000 and he will take 1,000 as advance. Priyansh gives 1,000, everything is fine. And rest after fitting the window. After 3 days, when technician tried to fit the window made by him at the site of Priyansh, it was noticed that the size of window was not proper. Priyansh requests the iron merchant either to remove the defect or return his advance. Iron merchant replies that the window was specifically made for his site and the defect cannot be removed nor is any use, so he will not repay the advance. Under sale of goods act in Kekram. Now, who is right here? Priyansh is right, buyer. That means either it's implied condition or warranty. Warranty means good is working, but some feature is not there. This another condition. The iron merchant, what to say, window in a so in implied condition is not met. Which one? Not sample, not title, not description. Mercantile. Mercantile quality. It's not meeting the purpose for which I purchased. Flask purpose, not keeping it hot. So implied condition as to mercantility is not met. So you can sue for damages, rescind the contract, do all of that. Condition as to quality or fitness. Yes, you can write that also. Ideally, you can write both. Description as to quality or fitness. I informed him I want this. Relied on seller's skill. That plus merchantability can be written. Priyan's request, I mean, either remove this defect or returns advance. Okay. 9 merchant. Correct. It can be quality of fitness. Let's look at the answer. Makes sense. Quality of fitness should be correct only. Which question? 8th one. No, let's see if they even wrote the other thing. Ideally, you can write quality of fitness because you relied on seller. There is an implied condition that goods should be in merchantable position at the time of transfer. Sometimes the purpose of which goods are required may be ascertained from facts and conduct of parties of sale, nature of description of article purchase. Buyer need not tell the seller. Okay, here they are saying why implied quality of fitness is not coming is giving explanation. Buyer need not tell the seller purpose for which he buys the goods. Quality of fitness enna varum? Buyer has to intimate the seller purpose why you are buying the goods. Here he is not intimating the purpose, not necessary to intimate. Like vaangna purpose, I am buying this, it should fit. No. If he deals there, you should specify I want that. No, if you are buying flask, you have to tell I want flask for hot water. Correct? Correct. See, ideally, in quality of fitness, seller should deal in that goods. Buyer has relied on the seller. Buyer has to intimate no to seller I want. No. See exceptions in caveat emptor. Let me see the book. I'll explain. அவன் என்ன சொல்றான்? No. What is trying to communicate there? I am seller selling only flask. வேற எதுவுமே இல்லை என் கடையில். I am seller selling only flask. Then you need not tell I need flask. The exception there is if seller is dealing only with one specific good. I am somebody who is selling only notebooks, long size notebook, rule notebooks. Then you need not specify the purpose. He is saying, see, if the seller deals only with that specific good, here is he dealing only with windows? He is an iron merchant. நிறைய work பண்ணுவான். So you cannot apply that principle here. Following? Yes, of course, we are going to go there. We are already there only. Point 8, RTP question 8. Just quickly have a read. I'll scroll down once you tell me. Online also can read. Which one? Which one? Last line, no? The buyer need not tell the seller the goods are required may be ascertained from the facts and conduct of the parties to the sale or from the nature of description or article purchased. In such a case, the buyer need not tell the seller the purpose for which he buys the goods. You are saying these wordings are from quality of witness. Then here the assumption taken is he is dealing only with that specific good. You can use both. Of course, you can use both the points. Merchantable quality and quality or fitness. 100% you can use both. Okay. Clear? Next. Question 43. Have a read. Agent. Correct. Residential property is not applicable. Let's see what they are saying in RTP. Oh, Maranta. Okay. He's treating as goods. You know the answer, guys. Is that goods? Sale of house, is it goods? So ideally, it's mistake. Your answer is correct. Residential property is immovable property. It's not a good. Goods means every kind of movable property other than immovable property and actionable claim. Correct. Clearly is mentioned. So this is what? Immovable property. He is applying the principles of agent, mercantile agent for immovable property. Ideally, it's a blunder in RTP. It should be corrected. Somewhere did they write? If it comes in exam, that's what I told you. If it comes in exam, write the provision as mercantile agent. Give a note. The above provision of Sale of Goods Act will not be applicable for residential property because it's an immovable property. However, assuming this is a movable property, this is the following answer. Are you able to follow, guys? That's it. Question 44. Quickly, guys, we can finish off in next 45 minutes maximum. Irkar only till 16 more questions to go. That's it. After RTP, past exam questions are easy. So keep reading, guys. 44. Quickly do a read. Things. These both are two joint owners of the property. They are joint owners of the house. Now what they are saying, who paid the full rent? Is Ram liable to pay whole amount to John? In case of joint promisor, you have to pay partnership also equal liability. Only half of balance you will recover from the other party. But what is the question? Ram and John said that Ram and Rahim are partners, therefore he can claim the full amount from any of the partner. First of all, are they partners? Is it partnership? Is it business பண்றாங்களா? There's not even a partnership. It's what? Joint ownership. We'll call that co-ownership. Still, even if it's co-ownership, who has to pay the money? It was decided that landlords and tenants that rent would be inclusive of electricity bill. Basically, even if it's co-ownership, one party can pay the whole amount and claim the other from other party. Same as joint promisor. But this is not a partnership, first of all. Correct? It is what? Co-ownership. Let's go look at the answer. Now, question 12. Partnership is giving definition. True test of partnership. Then he is saying Rahim cannot be said to be, whatever we answered only, cannot be said to be under partnership as they are teachers in a school, jointly purchased. They are what? Co-ownership. It's under co-ownership. However, hence there is no partnership between them. Therefore, Ram is liable to pay only 1,500. John has to claim the rest from Rahim. But in reality, is Ram liable to pay the whole amount to John? Basically, this becomes, if you apply principles of Indian Contract Act, it becomes what? Joint promisor. So even if Ram is paying the whole amount to John, he can recover 1,500 from Rahim. Are you able to follow, guys? So you can't write that, but what do we say? How do I put it? He is asking question as per Partnership Act. So as per Partnership Act, this is not a partnership, it's a co-ownership. Co-ownership, we share our own share of income and expense. So my share of expense is only 1,500. Following, guys. Next question 45. Go ahead, read it. In case of emergency, partner can act beyond his authority. Therefore, the sale is valid. He is binding the firm. Next, RTP June 23, question number 46. Doctrine of indoor management. This is the, what is the question saying? The article says company can borrow up to, and if you want to borrow more than 5 lakhs, company has to pass resolution in general meeting. Board gave an undertaking that bank has only been passed for such loan. The bank, on believing such undertaking, lend the money. On demanding the repayment of loan, company denied, saying it was ultra vires. The company kindly advise. Bank can only be aware that you have to pass resolution. Whether you actually passed or not my work. Doctrine of indoor management. The loan is what? Valid. It's defense, benefit for third party against the company. Following. Shorapurira. Next. Quickly go through, guys. Valida, voida. Just write fast. First one answer, guys. Void. A clause in a contract provides that no action should be brought upon in case of breach. Void. Second, where two courts have jurisdiction to try a suit, an agreement between the parties that suit should be filed only in one of the courts and not the other. Valid or void of? What is trying to say? If we both have a fight in case, I am saying don't file case in Madras High Court, file only in Andhra High Court. Is it valid? Agreement in restraint of legal proceedings is void only if it's a complete restraint. Correct? You are saying you can never file a case. That is void. Here I am creating a restriction that file in this court. This is not agreement in restraint of legal proceedings. It's only restriction. You are not completely stopping. Therefore, it becomes valid. Sometimes in contract they will put case will be dealt only in this jurisdiction. Are you able to follow, guys? X offers to buy, sell his Maruti car to Y. X believes that X has only Wagner. He agrees to buy. Mistake, void. Okay, their meaning also is not there. X, a physician and surgeon, employs Y assistant on salary of 75,000 per month for 2 years. Y agrees not to practice as surgeon. And is it valid, guys? Valid. Reasonable restrictions. Agreement and restraint of trade. 2 years reasonable. Are they 20 years photo? Void. It should be reasonable. 20 years or life munduru. Correct. From with this RTP questions are done. 47 RTP questions. Assume some 5 questions repeated, guys. Roughly 40 questions are passed from 21 we did RTPs. Now again from the same July 21 attempt, they are going to do past exam questions. Whichever I feel was difficult about, other questions are what is quasi contract, what are rules of contingent, direct and different question I didn't bring it. Able to follow, guys. So go through. MS one of the 4 partners in XY Enterprises. He owns a sum of rupees 6 crores to his friend Z, which is unable to pay on due date. He wants to sell his shares for settling the amount. In light of provisions of Indian Contract Act, can M validly transfer his interest by way of sale? What would be the rights of transferee if M wants to retire from the firm after a period of 6 months? That same provision we saw that section 29, that same one. First one, can he validly transfer interest by way of sale? Yes, section 29 of Partnership Act, transfer of interest. Same thing we saw above, interest can be transferred. Here, what would be the rights of transfer is that in case M wants to leave the firm after a period of 6 months. That means if M wants to retire from the firm after 6 months, what is M's right, retiring partner's right to get share of profit or 6% share of interest on property? Here, he owes sum of 6 lakhs to his friend is unable to pay on due time. What would be rights of the transferee in case M wants to retire from the firm after a period of 6 months from date of transfer? Z's right will be same. Share of profit, he will get share of profit. If the firm is going to be dissolved, share of property, same, not going to change. Resolution, yes. If firm is continuing, only profits, but firm is being dissolved because of retirement, then share of property also. Can he inspect books of accounts? No, you cannot inspect the. No, he's not partner. Section 29, interest only is transferred. That is not partner. Section 29, share of partner's interest. He is not the partner. If he is partner, of course he can inspect books of accounts. Sure, understood, guys? 100%. Same questions if I have to do for a regular batch, it will go for 10 hours, slow, 1 hour per stir. I should draw the diagram, then explain. First time they're doing it. I am presuming that you already learned, we are revising. July 21. Yes, you keep reading this. I'll download that. July 21. Oh. Okay, first I'll finish off this July 21 exam question. This one what we just now saw, the transfer of interest. Do you remember 6 crore question 1 and 2? 4B 6 mark question. Let's go read the answer. I'll just put it over here. Have a quick read. Provisions are here. Section 29, transfer of interest. Have a read of provision, then we'll go to the case. Can I scroll down? You will not become partner, but on retirement of partner, it will be against the remaining partners. You can only get share of assets which the retiring partners entitled, share of property, but ascertaining his share. But if the firm goes into dissolution, he is entitled to an account breakup. Accounts for dissolution of accounts, so dissolution of partnership, breakup of the share of property. You will still not be a partner. Can I take part in conduct of business? No. This concept of section 29, at least 3 to 4 times they tested in the past few exams, 21, 22. Okay. This he only see, he has to, if you see here, he owes a sum of 6 crore. So his interest, to the extent, whose interest? M's interest, to the extent of 6 crore in the firm is transferred to Z. Remaining will be given to M, retiring partner. Remaining will be given to M. Where is that? Remaining will be given to M. Next. Go to this, I think you already went through, guys. First one, Das sold the rice to one of his regular customers. She complained rice contained 2 different qualities and returned the same. Discuss the option open to Das for grievance redressal. First option is what? Das failed to notice that rice contained. One second. Das, general store owner, went to purchase. The wholesaler supplied the quantity exactly as shown in the sample. However, when Das sold the rice to one of its regular customers, she complained the rice contained 2 different quantities. 2 questions. Discuss the options open to Das For grievance, what would be your answer in case Das specified exact requirement of length of rice? First case, caveat emptor, Das has to be ordinary diligence. He should have checked. So when Das purchased it, he has to check. He didn't check, let the buyer beware. Second case, what if Das gave the exact requirement? Exception, sale by description. Buying goods by description, when buyer is giving the description, it has to match the description. In this case, he is not liable. Able to follow, guys? This answer also, since we have the paper ready. Same answer, guys. So first case, Das does not have any option for grievance, caveat emptor, because lack of due diligence on part of Das. Second case, description, implied condition. 50, guys, that's it. Last 10 questions. Question number 50. Enna kekrom? Whether the following is partnership or not. Go through. Go through, guys. Partnership or no, 6-mark question, December 21. Answer, guys. First one, A and B jointly own a car which they use personally on Sundays and holidays, and other day it's rent as taxi. What is it? A and B jointly own a car which they use personally on Sundays and holidays, and they let it on hire, Zoom car, as taxi on other days and equally divide the earnings. Partnership is two or more persons agreed to do a business. Are they doing the business here? And to share the profits. Is it partnership? Yes or no? Okay, we'll come back to first. Second, two firms having 12 partners combined by agreement into one firm. Yes. Two firms having 12 partners each combined by agreement into one. Still, firm area partners irukangla. Two firms are becoming one firm. Still, it's partnership. Second, yes. Third, A and B co-owners agree to conduct business in common for profit. Yes, of course, partnership. You are going to do business for profit. Third, some individuals form an association to which each individual contributes 500 annually. Objective of association is to produce clothes and distribute free. It's association of persons or Section 8 company, whatever. It's not a partnership. That's it. A and B co-owners share them between themselves. Rent derived from piece of land. Is it partnership? No, it's classic case of co-ownership. A and B buy commodity and agree to sell the commodity by sharing the profits equally. Yes, sharing the profits equally, it becomes a partnership. Now come back to first question. Now in this flow, tell me. See, let's say me and Yashwant own a car. Holidays we are using it. Other days me and Yashwant are giving the car to public. Uber, I'm giving it to taxi, I'm giving it on rent. So I have an app. Anybody can use my car, like Zoom car, to use it. Whatever profits me and Yashwant earn in this, we will earn the money. So look at the difference. In point 5 also, both are co-owners. They are sharing between themselves rent derived from piece of land. It's straight away income. Is there any expense? No. But here in hire, you have expense. It becomes a business. car petrol port, no, you're giving on rent, car service, all of that. Correct? So is this co-ownership or partnership? Co-ownership or partnership? How many of you partnership? First one, 51. Partnership. No one. One. How many of you co-ownership? It looks like a co-ownership. Personally on Sundays and holidays, and let it on hire as taxi on other days, and equally divide the earnings. What's definition of partnership? Three important things. Mutual agency. No, one person can act on the other. No. If I want, I can give the car on rent to let it on hire as taxi on other days. Let's check the answer. I think it's no partnership, but again, very close call, guys. Partnership or co-ownership, close call. Let's see answer. Based on my assumption and explanation, answer can change. December 21. December 21, question 4B, 6 mark question. 4B, come down. Both answers கொடுத்திருக்காங்க guys. அவனே கொடுத்திருக்கான். For first time, look at the answer. Suggested answer. No, this is not a case of partnership because sharing of profits or gross returns is common interest would not make them such person. Alternatively, can also be answered as below. Yes, it's a case of partnership as the car is used personally and holidays as taxi. It inferred that the main purpose of owning the car is to let it for business purpose. There is an agreement equally dividing the earnings. I told you it's a close call. So you would have got the mark. Yes or no with the right justification and the assumption. Here is taken what? Assumption. Are you able to follow, guys? Honestly, I didn't know which one to write. Yes or no. I have written one with my assumption. Okay. If it was me, I would have written co-ownership in exam. Okay. Rest are fine. Next, 51. December 21. Read it quickly, guys. Answer, guys. Can you reject or cannot you reject? Again, depends on what assumption I'm going to take. If you are TK and if you feel I exactly have a description of 1 inch, you want 1.4, so I cannot get, then you will reject. Other person, seller will argue saying it's commercially fit. For what purpose you want? It's useful for that purpose. Therefore, it is valid. They both will argue. Again, I need to look at the assumption. Timber 5A, 3 mark question only, thankfully. Quality or fitness. So here he is saying you cannot reject. What he is saying? Reasonable, as to reasonable fitness of goods for particular purpose may be implied if buyer made known to seller purpose of his purchase, rare upon skill, implied condition as to, it cannot be implied condition because it's still commercially fit. It's implied warranty na varu. So in implied condition you cannot use for the purpose. Here, instant case timber supplied by seller is commercially fit for the purpose it was ordered. It means implied condition on seller is you ask for a purpose, it is fulfilled. Hence TK cannot reject. Alternatively, guys, okay, description. You told what, guys? 1 inch. It is not there for 1 inch. I will reject. Implied condition as to description. Are you able to follow, guys? This is not RTP. Past exam question. You can give alternative answers wherever you have a doubt. Are you able to follow, guys? So one answer, one in benefit of seller, quality or fitness, one in benefit of buyer, alternative. Exam, can I write both? If you have both the answers, write both. Any one you are writing, correct. Above you write also is correct. This you write also is correct. Able to follow. So answer eppadi varudhu. It's based on which view? Seller's view or buyer's view. Are you able to follow, guys? Understanding? There's a reason why I pick these questions. If you look at December, okay, so December, if you go to the question paper, look at the other questions. What do you mean by the term capital? Classification of capital. Simple question. Then look at the other questions. If you go up, distinguish sale and hire purchase. Why do you want to discuss this in class? So I only put down those questions which are, what to say, unique, different from the regular question. So I don't want you to lose confidence. Again, if I go to some other question, go up. Look at the questions, guys. Define partnership, essential elements, any two, three marks. Then the minor borrowed loan, minor provisions, simple questions. I am not taking them, easy questions. Look at this. Explain 5 circumstances where contract need not be performed with consent of both parties. 7 marks. Why do I discuss? State the rules regarding registered office of an LLP. 5 marks. I am not discussing all this because it is straightforward. Registered office, what we discussed, guys. If you change, you have to update all of that. Clear? I only put those questions which is unique, different, out of the box question. Purida. Next. 52. Come on, guys. Only 8 more questions. I know you are tired. We can finish by 7 and we'll leave. 8 more questions only. That's it. Push yourself for last half an hour and then try to attend, guys. Anyone. Whichever you think is correct. If you want, write both also. If you have both doubt, alternatively giving your assumption. Go through, guys. In all the 3 cases, by filing a suit against Shristri, a minor, for recovery of outstanding amount by interest, can you do it? No. By filing a case against Ram, father of Shristri, can you recover? Minor cannot bind the father without the knowledge of the father. So if minor enters into a contract without knowledge of parents, you cannot go question parents for recovery. But if parents are aware, then parents are acting as guardian, then you can recover. Here they are not aware. Question is saying, therefore, no. Third one, by filing a case against Srishti, a minor, for recovery of outstanding, can she attain? Minor cannot ratify after attaining majority. So therefore, A minor for recovery outstanding of after she becomes maturity, majority, no. All the three are no, no, no. Exceptions. Every exam will have one question for minor, guys. Look at this. May 22 minor கேட்டிருக்கான். Before this, we saw somewhere. It will come. Every question, every exam, at least one minor question. Somewhere they will ask. Next. 53. Have a quick read. Again, same concept what we saw. I told you this concept repeated multiple times. Section 29. Adhe section 29, right of transferee's interest. A transferee, whoever that person is, the transferee cannot inspect the books of accounts. He only has right to receive profit. Adhe concept came in May 22. We saw in RTP, we saw so many. Other partners believe that he cannot be charged in the books. Can Pratik be introduced partner if he wants? Other partners should give consent. Regular provisions of admission. Admission is the majority, not majority. All partners should give consent. Then only you can admit. 54. Read it, guys, quickly. I want you to read because exam you are reading. Think and process. Just 6 more questions. Push yourself. That's it. Only 6. We saw this. Same question repeated. How it repeated, guys? First we saw in RTP. Adhe polish dana. First we saw in RTP. Now it's coming in past exam. Anga the white polish. Here, some diamond ruby stones. Adhe no. Another similar question. I'm just seeing is it fully same. I'm yet to read. Read the whole question, guys. But for the ruby stones, they will charge some extra cost. So beautiful set and paid for them. Okay. She also paid extra cost of ruby stones. Jeweler requested her to come back after a week for delivery. When she came back after a week delivery, the same bangles has been completely disturbed. Now she wants to terminate. Can she terminate, guys? Yes. You can terminate. Mercantile quality. What would be your answer if jeweler says he can change them but will charge extra cost? No, you cannot charge. Adhe answer though. Small lightly they are changing here and there. RTP question adopted in the main exam. Are you able to follow, guys? Here we are seeing. I didn't expect it to be Varun solely, but in the questions I picked, it got repeated. Understanding, guys, RTP how it gets repeated. May 22, it came. Next, November 22. We are going to the latest exam now. We are now in which exam? June 23. Generally, if you are in June 23, this exam attempt is, this question paper is less important. Are you able to follow? Latest exam, they will not repeat. Very, very rarely one question gets repeated. That's why I even mentioned only few questions. But still, let's quickly go through. Go through question number 55. Answer, guys. Doctrine of indoor management. Would your answer be different if a receipt under the company seal was not issued by C after receiving payment? Yes. Exception to doctrine of indoor management, suspicion of irregularity. When you have a doubt, you better go and check. So this entire provision is what? Doctrine of indoor management. This last line saying, will your answer be different? Yes. Suspicion of irregularity. Anybody wants me to explain? Anybody? See, if you are saying no, I am presuming those who are watching online recording later also will understand. So if you have revised it once, able to follow, guys. 56. Go to 56. This is differentiating between LLP and company. Nobody will do. They ask differentiating partnership and company. Table is there in LLP Act. It's a big table with difference. Write all those points. Difference table. Clear? Go to 57, guys. 56 answer, study matter difference is there. That table only. If you want that answer, I'll just show it to you. Which is which one? November 22. Difference table, guys. I'll just show it to you still for your. Wait. Quickly scroll. Do. Table, guys. The table is here. Okay. Next. Quasi contract is it? First point. Go through. I'll allow 1 minute, guys. Everybody read. Okay. Done, guys. First one. Will M succeed in filing suit to recover money? M is aged 21 years, lost his mental balance, incapable to enter into a contract after the death of his parents in an accident, staying with grandparents, okay. Necessities supplied to both. Can he recover? Yes. You can recover from his personal property, quasi-contract. Necessities supplied to a person incapable of entering into a contract, recover from personal property. Next, what is the maximum amount that can be recovered? What is the property here, guys? Jewelry 4 lakhs, only 4 lakhs. Balance amount, donation. Donation, I'm saying, you assume it's donation for the party. Shall the provisions of the above be applicable to medical treatment given to grandmother? Yes or no? Quasi contract says necessities provided to a person incapable of entering into contract and his dependents. Therefore, yes, even for dependents. The distinct quasi contract, I am able to follow, guys. His dependents, yes, him, and to the extent of property. The three concepts are tested in question. Exam, how to write this? In the question, fact, because they're asking straight away 3 questions. Fact is only when it's one case. Here, what you will write? Write the provision of quasi contract fully. Then in analysis and conclusion, write answer 1, answer 2, answer 3. With the answer, yes, you will give explanation. With the answer, maximum amount, 4 lakhs, give explanation. With grandmother answer, dependent, give explanation. That's my analysis and conclusion. Are you able to follow? Questions like this, don't write facts. Yes, maximum 4 lakhs, that's the property, no. Yeah. Whatever money is spent for dependents can be recovered. If the property is 15 lakhs, you can recover fully. Necessity, you can recover. Next question, 58, guys. Second, let the so first case is what is the answer? Quality or exception to quality or fitness, caveat emptor. Second is what? Caveat emptor. Let's quickly check the answer. 58 November 22 only. No, we have it ready. That should be the answer, but just cross check. Yeah, idana markana thing. 5A. Again, alternate answer. Two answers are possible. Latest exam. First, it is the duty of him to examine carefully before laying this. According to doctrine of caveat emptor, duty of buyer to satisfy himself before saying quality of. I mean, this is caveat emptor. Second one is saying what? He cannot make the seller responsible for defect in goods. Duty of buyer to make quality or fitness. Second alternative answer. I'll do one thing. Wait. What are the two answers you are concluding with? Wait, let me brief the question once for others' benefit. K visited Markana Marbles for purchase of marbles and tiles for newly built house. He asked the owner of the above shop J to visit the house prior to supply so he can clearly ascertain the mix and measurement of the marble and tiles. J agreed and visited the house on the next day. He inspected the rooms in the first floor and car parking space and insisted him to visit the second floor as well because construction pattern was different. J ignored the above suggestion. Another seller. Then J supplied 146 blocks of marble as per size requirements of the room and 16 blocks of tiles with a word of caution that tiles can bear only a reasonable weight. Marbles and tiles were successfully laid except on second floor due to different size of marbles. Whose fault? Seller. The tiles fitted in the parking space also got damaged due to weight of the vehicle that came for unloading cement bags. K asked J for replacement of marbles to tiles which J refused, taking the plea that marbles were as per the measurement and it was unsafe to fit tiles in parking area as it cannot take what? Heavy load. Discuss in details. Can J refuse both? Whether replacement is possible. Look at the answer first. Yes, J can refuse by using the principle of exception to doctrine of caveat emptor. It is the duty of buyer has to carefully examine. He didn't examine. It is not seller's responsible. So according to doctrine of caveat emptor, they are saying buyer. It is duty of buyer to satisfy himself before the purpose of sold. He is not reasonable. He is not taken care. Able to follow, guys. That is first case. Giving benefit to the seller. Second case is what? Making the seller responsible. Exception to doctrine of caveat emptor. Implied condition. According to caveat emptor, buyer can hold the seller responsible for defect in goods. For implied condition, if I gave some instructions, he didn't follow, seller did not inspect my second floor, that's the answer. In the above case, it is duty of the buyer to make known to J the purpose of his purchase. He has fully made the arrangement visiting to site. It is seller by neglecting the visit without going to second floor. So whose fault is it, guys? Seller's fault. Exception. First case they are saying without exception. Second case with exception. You can take anybody's stand. Same answer is given. Able to follow up. Sure, guys. 100%. Again, alternate answer, latest exam. So whenever you feel a doubt, write both. Give your assumptions. Clear? Next one. Question illa. Just for you to boost the confidence. Are you going to raise the question, guys? Hello? Yes or no? Yes. Next, 60th question. Read the question. This we will solve it after 6 months. Once you enter CA Inter. The CA Inter question, 60th, not part of your syllabus. Other I gave note. This question is not in syllabus. It's a CA Inter question. Just mention that you're telling closer to CA Inter. If you want to learn these concepts, enjoy the course, give your best for the next few weeks or months, you will be done with your foundation. Last two questions over. That's it, guys. So we are done with questions. I hope you had some value. We finished all the questions. Thank you.